of this community being on the cutting edge, and I was part of the city council that sued the federal government in order to ensure access to medical marijuana. In the city of Santa Cruz, it's a low law enforcement priority in law. In the county, it's de facto, as you've heard from the sheriff. And I want to make sure that what we're really talking about here is everyone can continue to have their 10 by 10 grow. Within the potential closed loop, we're providing the dispensaries with currently more supply than they say they need. We heard a little bit differently today, but we'll work on that and try to figure that out. We've also, that it's clear in this law that it's going to be complaint based. So those who have been cultivating for 10 years, 20 years, 30 years without any problems from their neighbors and friends will probably be continuing and able to do so. It's, the sheriff is only going after complaints, and so there's going to be plenty of adequate medicine for those in need. What we're trying to deal with is both the current situation, which we've heard clearly from the Bonnie Doon neighbors, and other rural, I've heard from my constituents of Bonnie Doon and from other rural areas, is an untenable situation as it is. And one of the speakers who described the potential ballot measure in 2016 as a tsunami is what we're all looking ahead towards, because it's one thing to cultivate and provide medicine for those who live within the county. It's another thing for our rural areas to become the supply for millions of people who live within an hour's drive from here. And we do not want those impacts growing in our rural areas. And frankly, not only of the impacts on the current neighbors, but if every RR and every RA parcel is now valued not on the basis of a family choosing to live in one of our rural areas, but is now valued on the basis of whether you can grow, whether you can cultivate marijuana on it, that's going to drive up already unaffordable home prices and land prices in our community. And that's a real problem. So I think what we're trying to do here is trying to find the balance that provides those in our community with the needs, with what they need, at the same time as making sure that we are not don't become the grounds for cannabis supply for the entire Bay Area or beyond that we've seen in other states. There's two small changes that I'd like to recommend to the maker. And the seconder of the motion is, so under County Council's recommendation under B5, it says that the cultivation is located on a parcel that borders any parcel located in a residential district as defined by Santa Cruz County Code. If you look at a map, that essentially eliminates every parcel, virtually every parcel in Santa Cruz County. I think what's more appropriate and what was meant by this is to have an appropriate buffer from adjacent habitable buildings on those sites. So you could have an RR house and then have a 25-acre ag parcel next door, and as long as that cultivation is going on far enough, several acres away from that house, I think we're trying to avoid the problem of being next door, not being down the road.
Yeah, well, I appreciate you bringing that up. I would support that, and I know that in our current regulations around agriculture, we require buffers between any agriculture product and the habitable structure. But I think our intention is to find a place where something can be grown, not to make sure it can't be grown anywhere.
What is the motion?
And I will actually, before I agree to the second, I just want to caveat it with, and I will end up agreeing to it, is the fact that in my district significantly is actually the most impacted by that. If I were to, I'm going to agree to it, just allowing buffers. So I'm going to be very concerned about what comes back via map to see how it reflects in my district, because the second district component on the adjoining parcels is actually a real issue. I respect that it's not as much of an issue for you.
If I could, I think that it might be better to come back with the variety of changes that your board is going to be looking for, rather than do it in a more of a piecemeal fashion, because the request that you're having today may have an impact on some of the other things that we're going to be bringing back to your consider. And so I just want to throw that out there, that what you might want to do is leave what's in place today as the motion was made, if that's the pleasure of your board, and then advise, instruct us to come back later with the variety of changes that you'd like to see made, all at once.
Which is what we intend to do unless you tell us to do something.
Sure. So, okay, yeah, so.
Now you know at least how some of us feel.
And so another thing that I'd like you to explore going forward is for the, if we do go with a closed loop system, that the growers who are legally cultivating, that they will be subject to inspections without notice, in order to make sure that they're growing for the folks that they said they would.
So then, just to specify then, that we didn't actually amend the motion beyond the initial.
Yeah, I mean,
Okay.
I think it's useful to put out what we're talking about, to see where you can massage this all together, given the various concerns.
Yeah, I appreciate the input of my colleagues and agree with that we should move on and move ahead and forward. I want to really thank the people that have been here throughout this almost year-long process. I mean, really, you've been really civil about, I know you're pretty intense in your feelings, but really you've been civil in what your presentations and what you think is important. And the most important thing is, as alluded to by Supervisor Friend, is that we want to see that there is enough medicinal cannabis to treat the patients within Santa Cruz County. That's our charge. It's not to export it to everyone else that's over the hill or elsewhere, but to serve the people of Santa Cruz County. And this is not going to be a perfect ordinance whenever it ends up in anybody's eyes, probably, in this room, totally. We've got state versus federal law, and we've got a November 16th or November 2016 election that nobody knows what is the content at this point. We just want to try to do the best we can do for the people that reside in Santa Cruz County, and that's our charge. That's what we want to try to do. And we wouldn't have gotten this far, and it's taken us some time without your input. So I do appreciate it. We have listened to you. I really look forward to moving this ahead in the near future when this comes back to us.
And most of everything that I've been thinking about and wanting to know about has been asked and pretty much clarified. There is enforcement. It's going to be after the people that really abuse the whole thing that we're going through. Complaint driven in the sense that people like yourselves are going to actually police the ones that are getting out of hand. That they're affecting everything, affecting what you're doing. Medical use is what the whole thing that I've been for. I'm not for the recreational use, but medical use, you bet. That's what I want to see happen. We're talking about permits and licensing, and I like the idea of inspections. And so, and I want to thank staff also, especially county council, because I've been following the lead on you on this, because you've been putting in all the research, the time to make sure what we're doing is actually semi-legal. It's not fully legal, but it's semi-legal. So anyway, I just want to make sure what we're voting on now, there's
Let me go ahead and
something
restate.
final taking place.
Yeah,
here.
let me restate the motion with changes. A motion was made by Supervisor Leopold, seconded by Supervisor Friend, to approve the recommendation number 2 in the letter of the county administrator, planning director, and sheriff to return with possible recommendations on a third-party certification on or before March 24th, to present recommendations on appropriate buffers rather than prohibited zone district adjacencies as an option, and to provide for inspections without notice. So that's the motion that's on the floor at this time.
Yeah, I mean, I actually thought those last two pieces were just information. I wasn't sure they were part of the motion. Just that we want the county council to come back no later than the 24th. That it would be good to have a third-party certification, and that for the comments that were made here today from Supervisor Cooney, Supervisor Friend, and others, to try to incorporate those. But you know, I haven't talked with Supervisor Cooney about the inspection thing. I'm not even sure how I feel about it, so I don't want that.
No, we would just be bringing you possible recommendations in consideration of those items. We didn't understand them to be incorporated.
Okay. That's it. Reasonable to everybody. Let's have a vote. Okay. We have a motion, we have a second. All those in favor, aye?
Aye.
And those opposed? We have a unanimous decision. Thank you.
It's all going to height. That's right.